Good morning, everyone. Thank you for all of those of you who've joined us so far. We'll be beginning very shortly. We're just leaving it a couple more minutes for some more people to join us. Good morning, everyone. Thank you for all of you who've joined us this morning for our second Brexit and Beyond webinar on the topic of the new UK migration rules, for which we're delighted to be joined by Blanca Gray from the UK Home Office. I'm now going to hand over to Eduardo Barachina, who is the President of the Spanish Chamber of Commerce in the UK, who will just be giving some opening remarks.
Hannah, can you all hear me?
Yeah, we can hear you. Yeah.
Can you see me?
Yes.
That's splendid. Well, thank you very much, everyone, for joining us today in this second Brexit seminar that we, the Spanish Chamber of Commerce, has launched in collaboration with different departments of Her Majesty's government. The bilateral trade between Spain and the United Kingdom go far beyond mere economic figures, and it's heavily based and dependent on a huge interaction between British people in Spain and Spaniards in the United Kingdom. Indeed, there are hundreds of thousands of British people living in Spain and 100,000 Spaniards call UK home. And this obviously requires and demands knowledge and discussion on the new rules following Brexit. We're delighted to continue our conversation on migration rules with the Home Office with Blanca Gray today. Last year, we were privileged to have Minister Kevin Foster, who came to one of our seminars for the members. And today we have Blanca with us, who will share with us a number of important aspects that we need to take into account when visiting the United Kingdom, when arranging visas applications, to understand the new points-based system that the UK has launched. And generally, that's probably the key aspect for our companies, to understand how things will change now when hiring people, skilled, not skilled, to the companies. We are the 6th, 7th investor in the United Kingdom, and we're very keen to not only to continue with these levels of investment, but we're also very keen to go up and improve. And essential to that is obviously how we facilitate movement between workers and people generally. So I'm delighted to welcome Blanca here today. Blanca, we all hope to meet you at some point personally when circumstances allow. And on behalf of everyone at the Chamber of Commerce, thank you very much for your time. Thanks very much to your team and to the Home Office for spending some time this morning with the Spanish Chamber of Commerce. Thank you very much.
Good morning, everyone. I hope everyone hears me okay.
Yeah, all good.
Oh, brilliant. Can you all see me as well? Or?
Yeah, we can.
Oh, brilliant. Okay. Hi, good morning, everyone. Delighted to be here today. My name is Blanca Gray. I work in the external engagement team at the Home Office, engaging on the new immigration system. And I'll be joined by my colleagues in the policy areas, particularly to the new immigration system. to answer your questions at the end after the presentation. So without further ado, I'm going to share my screen. So I'll be speaking, I'll be going through some slides that hopefully will cover pretty much every aspect of every relevant aspect of the new immigration system. I promise it won't be too long, and then we'll have time for questions and answers. So I'm going to share my screen. Just a second, bear with me. Okay, can everyone see it?
Yeah, we can.
Thanks. Okay, brilliant. Fantastic. So we thought it would be useful to start with giving you a little bit of recap, a bit of a summary of the EU settlement scheme first, before diving into the core part of the presentation, which is the new immigration system. But just to start with a couple of slides, just to recap on the EU immigration and on the EU settlement scheme. So first of all, just a few recap points. So some key headlines. So the EU, EA, and I'm sure you know this, so I'll go pretty quick. So EU, EA, and Swiss citizens and their family members still have some time. It's not plenty of time anymore because obviously the deadline to apply to the EU settlement scheme is coming soon. So it's on the 30th of June, 2021. And so for those living in the UK, for those who were living in the UK by the 31st of December, 2020 are eligible to apply. And as I said, there's still a few months to apply until the 30th of June, 2021. So that remains in place. During this period, employers, landlords, and public service providers will continue to accept passports and national identity cards of EU citizens as evidence of permission as they do now. So that doesn't change until, as I said, the 30th of June, 2021. The latest statistics are pretty healthy. It shows that we received about 5 million applications up to the end of September last year, and just under 4.7 million have already received status. So it's going very, very well, the scheme. And still quite a few applications still arriving every day. Status under the scheme protects in UK law the current rights that EU citizens have under EU law, and they will continue to be eligible for public services, public funds, and pensions as they do now. They will also be able to apply for a British citizenship if they meet the requirements, should they wish to do so. And as I said, from the offset, the Home Office has reasons to grant people status and not to refuse. So who needs to apply? In short, everyone, those who are here before the 31st of December 2020 and who wish to live and work here after that date. Again, those with permanent residence under EU law will need to apply, so they get a status under UK law. And those with ILR, so with indefinite leave to remain, can also apply if they wish. How to apply? Well, the system is very straightforward. It's easy. It's only 3 steps. The application process is quick and user-friendly. And eligible citizens who apply, they will get either pre-settled status or settled status. So I'll explain that in a little bit more detail on the following slide. So first of all, we need a proof of identity. So we need to know that the applicant is an EU national and they can use a passport or national ID card. That can be verified by post, in person, obviously COVID restrictions permitting, or via the use of the app, which allows applicants to read the data on their passport and take their own photo, much like eGates. This is available on Android and Apple. Second, we need a proof of residence. So we just need the evidence that the applicant has been resident in the UK, not what they've been doing, just that they have an address in the UK. And the easiest way to do so is where the applicant chooses to provide their national insurance number in their application. So we will carry out automated checks of records held by HMRC and DWP just to establish if this can evidence that the person has been living in the UK, and also the time that the individual has been living in the UK. So for those purposes only. To be honest, around 3/4 of applications do not need further evidence, so just using the national insurance number. Obviously, if the individual does not have a national insurance number, that's okay. There are plenty of other documents that they can be used in order to demonstrate that the individual has been living in the UK. For example, council tax bills or bank statements, letters from GP, school addresses, etc., etc. There is a whole list of documents that can be used on gov.uk. And the third step is the criminality. So there is a criminality check on every application. Okay, so I think this is the last slide of the EU settlement scheme. So just to recap as well. So whether someone has a pre-settled settled status, so that's determined by the number of years. So pre-settled status is for someone who's been living in the UK by the 31st of December 2020 for less than 5 years, and settled status for those who've been here 5 years or more. Based on the information provided, they will be given either pre-settled or settled status. For settled status, a person, as I said, needs to demonstrate 5-year continuous residency. So continuous residency means that they have to be living in the UK for 6 months in each year. Those who do not have 5 years continuous residency, they would get, as I said, pre-settled status, but they are with the ability to convert that into settled status once they accumulate a 5-year continuous residency. Okay, right. That's about it, the EU settlement scheme. So let's dive into the main core of the session today, which is the UK points-based immigration system. And as I said, I'll be speaking for another 10-15 minutes, and then we'll have a time for Q&A. Okay, so I'm going to start with giving you an overview of the skilled worker route. So anyone coming to the UK for work, including EU citizens, need to demonstrate that they meet a specific set of requirements for which they will score points. So we have made the necessary changes so it is simpler for employers to attract the best and brightest from around the world to come to the UK to complement the skills that we already have. So a particular feature of this route is that it gives employers the flexibility by allowing applicants to trade points if they have the relevant qualifications or work in a shortage occupation. It is also more flexible than the previous Tier 2 route for skilled workers. The requirements are as follows. So first of all, the applicant must have an offer of a job from an approved sponsor. Secondly, the applicant must speak English to an acceptable standard. There will be a criminality threshold. The job must be at the minimum skill level, so RQF 3 level or equivalent and above, so A level or equivalent qualification. Fifth, workers will not need to hold a formal qualification. It is a skill level of the job they will be doing, which is important. Next, migrants must meet the required salary for their job. And this will be either the general salary threshold, which on the advice of the Migration Advisory Committee, we lowered to £25,600 per year. Or it will be the going rate for the job if it is higher than the general salary threshold. So just to recap, what is new? So there are a number of elements which are new for this immigration system, and they are as follows. So first of all, the cap on these routes has been suspended. Second, there is no resident labor market test, which has now been removed. Thirdly, the skills threshold has been expanded and the salary threshold lowered, as mentioned earlier. There are tradable points for certain characteristics. So, and I will go through what this means in practice and work through a couple of examples so you can see it in practice, what this means. Then the 12-month cooling off period and 6-year maximum length of stay in the route have been removed. Okay. So moving on. Right, so just a little bit more details, so bear with me. So when we say points, what do we actually mean? So applicants need to score a total of 70 points, okay? So by meeting the mandatory criteria, which are a job offer, skill level, and English language, they already score 50 points. To qualify for a skilled worker visa, they must obtain a further 20 tradable points through a combination of points for their salary, a job in the shortage occupation, or a relevant PhD. So for every occupation, there is a required salary that the migrant has to be paid. So this is the higher of the general salary threshold, so £25,600, or the going rate for the job. So the appropriate salary for each occupation is actually set out in Annex E, which is on gov.uk, of the further details document, which was published on the 13th of July. It's not a very long document, actually. So for example, a civil engineer is required to earn £35,000, and the quality assurance technician has to earn £25,600. However, it is possible to reduce the salary requirement if the applicant, if the migrant can score points for the attributes or the nature of the job. So for example, if the job is on the shortage occupation list, the migrant can get a 20% discount. If the migrant has a PhD that is relevant to the job, that is worth 10% discount, rising to 20% if the PhD is in a STEM subject, so science, technology, engineering, or maths. Also, a new entrant to the labor market can secure a 30% discount on the salary. So those discounts apply to whatever sum the migrant would otherwise need to earn for that particular occupation, whether that figure is based on the general salary threshold or the going rate. There is also a general floor of £20,480, below which a salary cannot drop. So for example, a number of public sector occupations are subject to separate arrangements based on a published pay scale, such as GPs. The salary requirement for new entrants will be 30% lower than the rate for experienced workers in any occupation. However, the minimum of £20,480, as I said earlier, must always be met. So that's the floor salary. We will retain the ability in the future to increase the number of attributes that will score tradable points to enable us to meet the needs of the economy. However, the mandatory requirements will not be tradable. There is, again, there is a lot of, and I'm sure you've already seen it, there is further worker examples on tradable points that cover different scenarios in the introduction to employers available on gov.uk. But in any case, I'm going to, in the next couple of slides, I'm going to explain these points in a bit more practical terms so you can see it. Okay, so let's start with the case study number 1. This case study demonstrates how a skilled worker can come to the UK. So as already outlined, an applicant needs to achieve 70 points overall. So in this case, the individual is a lab technician. She meets the 3 mandatory requirements, so she achieves 50 points. But she has been offered a salary of £21,000, which is below the general salary threshold of 25,600. So she doesn't score any points for salary. But as it is above the lower limit threshold of £20,480, she can trade the remaining 20 points, okay? So let's say The applicant holds a PhD in a STEM subject, which is relevant to the job, which provides her with those 20 points. She therefore accumulates the required 70 points. Okay, so that's case study number 1. Let's just move on to the next one. Case study number 2. So in this case, this individual has been offered the job as a mechanical engineer. He meets all the mandatory criteria, so he scores 50 points. As the going rate for his occupation is higher than the general salary threshold, he needs to meet that going rate to qualify, which for mechanical engineers is £33,400. His salary is £26,700, so it's just above 80% of the going rate, so cannot trade any points that way. However, as this is a job which is in a shortage occupation list, he receives the 20 points that way, and he reaches the 70 points required. So that's how the tradable points work. But as I said, there are other case studies which you can go through published on Gov.uk. All right, so let's move on to sponsorship. So here, employers will need to become sponsors to bring in someone to work or study. So we have engaged extensively and listened carefully to businesses and have made a number of changes to the way employers can sponsor a migrant. So we have, as I mentioned earlier in the presentation, we have removed the resident labor market test and suspended the cap on numbers. So there's no longer a monthly panel for certificates of sponsorship. So cumulatively, this means a reduction in the process of around 8 weeks, which is pretty good. Employers do not need to be sponsors to employ someone from the resident labor market, including, as I said earlier, more than 4.7 million EU citizens who have already applied to stay under the EU settlement scheme. And we now allow migrants to switch into a different route without having to leave the UK. They will, though, need to meet the requirements of the new route, of course. We have also been working with employers directly and through advisory groups, including a dedicated SME group. And this is not the end, of course. So we will make further improvements to the sponsorship system in 2022, which will be testing with users. Okay. Right, so for those who don't meet the skills salary threshold, so the UK, as I mentioned, the UK points-based immigration system does not seek to replicate free movement and does not include a route for those who do not meet skills and salary thresholds or temporary work. We need to shift the focus of the economy and concentrate on investment in technology, automation, and training up the UK's domestic labor force, particularly given the impacts of COVID-19. So employers will need to adjust. So the new immigration system provides greater flexibility for employers with changes to salary and skills thresholds. The Migration Advisory Committee, it's worth noting that they noted that in the absence of a route for lower skilled migration outside the EU, there are an estimated 170,000 recent non-EU citizens in lower skilled occupations. So that's worth noting as well. And finally, both the seasonal worker pilot and the youth mobility scheme will provide employers with further flexibility as well. Right, so moving to the visitors route. So anyone can apply to visit the UK. They must either apply for a visa before arrival or seek leave to enter at the UK border. So visa nationals can apply anywhere outside the UK. Non-visa nationals can apply at the UK border. So in most cases, visitors can come to the UK for up to 6 months. A visitor may enter the UK multiple times, but they may not live in the UK by means of repeat visits, and they may not work or access public funds. We will permit study of up to 6 months under the visit route. Also, all non-recreational study must be undertaken at an accredited institution, so that's worth noting. Recreational courses undertaken for leisure that last no longer than 30 days and which do not lead to any formal qualifications will not need to be undertaken at an accredited institution. And also worth noting that the UK government has already said clearly that citizens of the EU and Switzerland do not require visas to visit the UK. Okay. A bit more information. Sorry, this slide is a little bit packed with information, but hopefully we'll be able to send you the PDF version of the presentation at the end, so you can read it at your own leisure. Although that information that is on the slide is on gov.uk anyhow. So just to say that we recommend that everyone reads the visitor rules, as there are a number of activities that can be undertaken under the standard visit route, including meetings, conferences, negotiating contracts, and taking part in research. So there is we hope clear information on gov.uk on what sort of activities are permitted under the visit route. Okay. Other routes, for a number of the main economic routes, the main change that has been implemented for January 2021 is bringing EU citizens into the current non-EU routes, or examples are listed on the slide. It is a long list, you can see on the slide, which includes routes such as startup, innovator, and charity routes. In the longer term, underpinning these routes will be simplified guidance and rules, and will make the best use of the technology and best practice from the EU settlement scheme. Intra-company visas, I think that's quite relevant. So one of the routes opened up to EU nationals is the intra-company transfer route. There are two intra-company routes. So first, the intra-company transfer. So this is for established employees who are being transferred by their overseas employer to do a skilled job for a linked employer based in the UK. And second is the intra-company graduate trainee. So this is for employees taking part in a structured graduate training program who are being transferred by their overseas employer to a linked employer in the UK. So to qualify for an intra-company visa, an applicant must be an existing employee of an organization that's been approved by the Home Office as a sponsor, have a certificate of sponsorship from by the employer with information about the role they've been offered in the UK. They need to do a job that is in the list of eligible occupations, and they need to be paid at least £41,500 for an intra-company transfer visa, or at least £23,000 for an intra-company graduate training visa. So again, there is plenty of information on gov.uk, and I put the link on the slide at the bottom. I thought it would be worth just discussing briefly the right to work checks. So right to work checks for EU citizens, and I briefly touched upon this earlier in the presentation, will not change until the 30th of June 2021. So until then, EEA citizens can use their passport, national identity card to evidence their right to work. So during this time, employers will not be expected to differentiate between EEA citizens who arrived before the end of the transition period, so on the 31st of December, by the 31st of December 2020, and those arriving afterwards in the grace period. I'm talking about during the grace period, which is from the 1st of January 2021 to 30th of June 2021. EEA citizens with status under EU settlement scheme or the points-based immigration system may choose to use the Home Office online service to evidence their right to work. So what is called the digital right to work checks. So which we understand that many employers are already using. So during the grace period, employers cannot refuse to accept a passport or ID card from an EEA citizen, or insist they use the Home Office online check-in service to prove their right to work during this period. So there is, again, we've recently published a leaflet which clarifies the right to work checks during the grace period. It's understanding your right to work, EU, EEA, and Swiss citizens. I included the link on the slide to the Gov.uk information. And I'm just coming to the end. So the last couple of slides, they have links to all the information that we have already published in terms of assets and resources. So we have made information available on gov.uk on the introduction of the points-based immigration system from 2021, including a page on what you need to know, which will be updated with the latest information as it becomes available. So from this page, you can also access other information such as the policy statement and further details document. We have published information to prepare employers on how to sponsor someone to work in the UK as an employee. And we have also published information to prepare EU, EA, and Swiss citizens who want to work or study in the UK from 2021, which will be translated into 25 EU languages, including Welsh. So the translated versions will be uploaded onto gov.uk in due course. All right, so I've come to the end of the, there's more links to gov.uk. But as I said, I will be sending a PDF version of the presentation soon after the webinar, so that you have all the information and the links relevant to what you are looking for. All right, well, thank you very much. And I'll stop sharing my screen and then we'll come to the Q&A session. Thank you.
Great. Thank you so much, Blanca. It was super interesting, really informative. So we've got some questions come in already, and yeah, so I know you've got some of your colleagues who might be joining you, right, to answer some of those. Just everyone, so you know, there's the Q&A tool at the bottom of your screen there, and also the chat function. So please just write in your questions via there. Okay. So our first question we've got is, do companies need a sponsorship license as a company to be able to then employ staff from abroad?
Yeah, that's correct. That's for the skilled worker route. Companies will need to acquire a sponsor license from the Home Office. Richard, do you want to add more of the detail on that?
That's basically it. There's a lot of guidance that we publish on how to become a sponsor, but essentially, yes, if someone doesn't have other permission to work in the UK because they've applied to the EU settlement scheme, or they've got another type of visa that allows them to work, then they would need to be sponsored, and the company sponsoring them would need a license.
Thanks, Richard.
Brilliant. Okay. Now Chen Chao Huwu, who's from a patron member of the company Del Canto Chambers. She's just joining now to ask a question live. Okay, over to you, Chen Chao.
Thank you. Thank you very much, Mrs. Gray, for sharing an overview of the new UK immigration rules. We are Spanish chambers in London with strong presence in Ibiza, and you cannot mention Ibiza without mentioning great music and great artists. So my question here would be if there is any plan to facilitate visas for artists from the United Kingdom and vice versa from the European Union, so that tours and concerts are not interrupted once we return to the normal. Thank you.
Yes. There's going to be information on creative routes, and I think we are in the process of updating information on gov.uk, which explains exactly what sort of routes will be available for those coming to perform as artists, etc. I'm not extremely close to that policy part, but I don't know, Richard, whether you are, or maybe we may take that question away and provide you with further information once we are a bit clearer on the actual routes.
I think it's one we probably need to take away. I mean, there are different options already. there's our permitted paid engagement provision under our visitor rules, which does let artists come to give performances without needing to apply for a work visa. Others will need to be sponsored under our temporary creative worker route, but I'm not massively familiar with either of those routes, so it's probably best we take that away and give advice from the colleagues who lead on those routes.
Yeah, that's right. But yeah, you are absolutely right, Richard. Thank you. It's worth looking at first at the visitor route that I mentioned. I think it was slide number 21, I think, where there are, it's very clear the rules, and there's quite a lot of options that permitted activities. Yeah, that's the terminology that you can do under the visitor routes. I think worth looking at that first. But yeah, as Richard mentioned, we'll take that away and we'll provide you with further information from our policy leads on that particular route.
Perfect, thank you.
No worries.
Great, thank you very much, Chen Chao. We're also now joined by Johanne from Santander, which is another patron of our chamber, and Johanne is going to ask the next question. Over to you, Johanne.
Hello, Blanca. Thank you so much. I don't know if you can hear me.
Yes, I can hear you very well.
Great. Thank you so much for this insightful presentation. I think it's a very important topic to be aware of. And my question is regarding, so because all this bureaucratic stuff now that we have to go through in order to work in the UK, how do you see the future? How do you foresee the future of remote working? So for the UK company to avoid all these sponsorship, visas and stuff, working from Spain, for example, for a UK company remotely, how do you see, because we are on a global, right, an international movement and things like this. Just curious to listen to your thoughts.
Right. I think in terms of remote working, obviously taking into account all the COVID obviously has certainly made that remote working become more normalized, isn't it? I mean, in terms of the routes, I don't know, Richard, whether you want to say something about that, because obviously I don't think we are making specific reference to that remote working on our rules. Am I right?
We don't at the moment. We know it's something that obviously the world has changed when it comes to remote working, so it's something we want to think about with future changes to the rules. I mean, if somebody isn't coming to the UK at all, they're simply remote working in a UK job from whichever country they're based in. They obviously don't come into contact with the immigration system at all, and we don't have any restrictions there. What we were interested in looking at going forward is people who are remote working a job in another country while they're based in the UK, or people who are mainly remote working a job in the UK but occasionally need to come in for the odd piece of work or the odd meeting. So those are two areas we want to look at in future, but it's not something we have a policy on at the moment.
Thanks, Richard.
Great. Thank you for answering that, and Johanne, thank you very much for asking your question there. Okay, so we've got a lot of other questions come in, which is great. Another question is, this is one which we've been asked quite a bit about at the moment. Are there any routes specific for internships to be offered to EU citizens?
Do you want to pick that up, Richard?
Yeah, so there isn't a specific route for internships, but we do have, it's got the rather complicated name of government authorized exchange, which is one of our temporary work routes. And that's got a number of different schemes in it, which can include training programs, work experience, internships, and so on. They are schemes that have to be sort of overseen by an umbrella body, so it doesn't work for a company that's just doing its own in-house internships. But in-house internships could be done under the skilled worker route. We also have a specific graduate trainee category under the intra-company routes. So they should be able to be accommodated in the existing routes, but there isn't a specific route for them.
Okay, great. Thank you. Yeah, because there's just another question we've received also that's kind of a bit linked to that question on the topic of internships. Because it's talking about whether they require the tier 5 visa and the certificate of sponsorship. I'm sorry. Is that yeah, just about that as well?
Yes, so the tier 5 visa, that's the government authorized exchange route that I mentioned.
Oh, sorry.
So both that route and the skilled worker and intra-company routes, they would all need a certificate of sponsorship.
Okay, brilliant. Thank you very much. All right, another question that we've had is on the topic of the intercompany transfers. Is the list for eligible occupations fixed?
Are they fixed, Richard? I'm not sure.
Yes, so
Okay.
I think our colleague Ragnar's on the call, but I think he's having technical problems, so I'll pick this one up if he's not able to join in.
Thanks.
Yeah, so like the skilled worker route, we have a list of occupations which are eligible for that route, and that list is set out in our immigration rules. For intercompany transfers, the skills threshold is set slightly higher, so we're looking at graduate occupations only for that route, but the list of those is all set out in our rules and guidance.
Brilliant, thanks very much. Another question that we've had is what will happen to employees who are currently working with us but have not applied for the settlement, but haven't applied for the settlement scheme by June 2021?
Yes, excuse me. That's obviously, as I mentioned earlier. Let me just go back to so the right to work checks. We've been very clear, and we published a leaflet, which I think I put the link on the slide, to right to work checks. So for those who we are not requiring, we are not mandating employers to do any retrospective checks on those employees who've been working with you. So we are not expecting you to differentiate between those who have been living here, those who are already working with you, but those who live here already, been living here from before the end of last year, and those who are who have been coming after January. Obviously, so during the grace periods from the 1st of Jan to the 30th of June, we are not mandating employers to do any retrospective checks. Now, in terms of what happens after the 1st of July, we are working out proper guidance that will explicitly specify what the role and responsibility is for employers. In case, for example, obviously it's very clear that, you know, if you employ someone after the 1st of July, that's new person, obviously, you know, if he's been living here in the UK for before 31st of June, the 31st of June, sorry, 31st of December 2020, then obviously will be eligible to apply to the EU settlement scheme. But if you're made known by someone who has not applied to the EU settlement scheme after the 30th of June, obviously this person will be unlawful living in the UK. So we are, in the next few weeks, we'll be publishing guidance for employers on what to do in those scenarios. So bear with us.
I'm sure that'll be really useful. Thank you for letting us know about that. There was just a follow-up question on the topic of the intercompany transfers that we just spoke about a moment ago. How long is the visa valid for once obtained? Is it the length of employment or?
Yes, so it's however long it's kind of up to the employer really how long they issue that certificate of sponsorship for, and it can be anything up to 5 years.
Brilliant. Okay, thank you very much. Someone else has asked a question about short-term business visitors needing to apply for skilled worker visas, but I know you had your slide about that, and so people coming for business trips, they don't need any kind of visa, do they, therefore, if it's under 6 months?
Yeah, that's for visit visas. So the visitor visa allows visitors to be in the UK for up to 6 months, and And yeah, we made clear that they are not required a visa. So we will publish more information, further information on that later on.
Okay, thank you very much. Another question that we've had, I'm just thinking how to word this correctly. So if an undergraduate student's doing short placements at UK universities don't require a visa, if the same student applies for the Erasmus Plus program to do the same activity, why is it that they require a Tier 5 visa? I think there's a little bit of confusion on that topic with studying. Maybe you could help us with that.
So we may have to take that question away, Richard, unless you are familiar with this, with the Erasmus Plus and the student route.
No, I think we'll need to defer that one to our student colleagues.
Okay. All right. No worries then. Okay. So then just one last question that we've had at the moment. Is how do I bring my this is kind of more general, is how do I bring my spouse, child or dependent to the UK? I suppose this is someone speaking as if they've got their visa to come here for work.
If it's somebody who is joining someone in the UK who has applied to the EU settlement scheme, then yeah, we are clear. I don't know from the top of my head, but they are able to join. They are EU national in the UK. I think indefinitely. I'll have to double check that. But if the family member joins somebody in the UK who's eligible to apply to the EU settlement scheme, and obviously has applied to the EU settlement scheme, that provision is there. Now, in terms of the new immigration system, Richard, are you more familiar with that?
Yes, so if they're coming on a work visa, almost all of our work routes allow you to bring immediate family members as dependents. So spouses and partners and any dependent children under 18 can apply as dependents on a work visa, and they can apply at the same time or they can apply to join later. And we've obviously got forms and guidance and so on set out for all of that. I think the only exceptions are a couple of our short-term routes, so things like the youth mobility scheme and the seasonal workers route. You can't bring family members with you, but all of our other work routes you can do.
Brilliant. Okay, thank you. So we've got some more questions come in now. I think another one is someone has asked if the employee we've sponsored has resigned, can we use his or her visa for new employees, and can this employee work somewhere else, kind of directly, as in, like, I suppose, within the same organisation?
So a sponsored work visa is very much linked to one employee, one job. So if that person wants to change job to another employer, they would need to get a new certificate of sponsorship from that new employer and make a new application to us. And similarly, if the company wanted to replace them with somebody else who also needed sponsorship, then they would need to issue a new certificate of sponsorship for that person, that they're not transferable.
Great. Okay, thank you.
I should probably just qualify for that if it's the same person doing a different job within the same company, then there's a bit more flexibility because it's still same person, same company. So their job can change while they're working for that sponsor to an extent. But it's if the person or the employer is changing, we would definitely need a new application.
Okay, brilliant. Thanks. Another one that's again linked to the so we've still got quite a few coming in here, which is great. But one is will EU citizens continue to use the same channel as before at the UK border to gain entry?
I think this is, again, we are going to publish information on that very soon.
Fair enough.
Yeah.
If this is about the e-gates, the electronic gates, the sort of fast track lanes at the ports, then yes, they'll still be able to use those.
Okay, great. Another one is when a worker is sponsored to enter the UK, is it the worker or the employer who is responsible for applying for their visa?
So this is where the sort of certificates of sponsorship come in. So that's the bit that the employer fills out, which has all the details of the job that they're being sponsored for and the salary and so on. The worker then uses that to make the visa application. So they make the application themselves, but by including the reference number from this certificate from the employer, a lot of those details are provided to save them having to tell us again.
Okay, brilliant. Thank you. Okay, great. I mean, there's Richard, I think you can hopefully you can look at the questions that have come in the Q&A. Maybe you can, because there's some, again, they're linked to education and research that I'm not sure if you guys are, or it might be better for a colleague of yours to answer.
Yeah, I can see here there is a question also about whether there's going to be a webinar on specific routes such as the creative worker route. I mean, I think it would be worthwhile. So Hannah, maybe, you know, we can arrange that in sort of in due course.
Yeah, so,
that's fine.
Certainly.
On the creative workers route, that should be fine. That's no problem at all. And I think maybe linked to that, we can also get policy colleagues who are specifically looking at the student route and the Erasmus, et cetera, sort of aspects related to the student route, so that can be arranged as well. So yeah, we can do that.
Yeah, and the question about a work placement, if that's part of a UK degree course that the student has to do a work placement, that will be covered under their student visa. They won't need a work visa if it's part of their course.
Okay, great, brilliant. Thank you. So someone has asked again about just with regards to intercompany transfer, how that affects the family of the worker, but I think that'll be covered on what I asked before, right? About what the previous question about.
So it's the same as other work routes. Intercompany transfer workers can bring their partners and any dependent children under 18 for the duration of their stay as an ICT.
Okay, great. Okay, I think so. Some of the questions we've been having are quite specific. So just I think if anyone has any kind of follow-up questions after this, is it all right if we share those with you?
Absolutely. Yeah, Hannah, if you can send
Brilliant.
them to me, and then I can always get the you know, sort of distribute them to the right policy leads, and then we can get your answers. So yeah, any other questions, any follow-up questions, send them to me. No problem.
Okay, yeah, I think that's maybe better, because there's obviously so many nuances with all of these things. Cool, thank you so much. Well, yeah, brilliant. Thank you very much, Blanca, and also Richard as well there for answering all those questions. It's great we got so many, but I appreciate there's lots of little details and kind of all of them. But it was a really useful presentation. Which hopefully, if it's all right, we can share with the participants afterwards. I think you mentioned that before, right?
Yeah, okay. No problem. Yeah.
Great. So I will, all of you who've joined us, thank you so much for joining us today. And I will be circulating later on today the presentation that was used. And also, if you have any further questions, you can let me know about those. But yeah, thank you both, Blanca and Richard, for your time. And Eduardo, I'll hand back over to you to say some final words.
Thank you very much. On behalf of the Chamber and all the members, Blanca and Richard, thank you very much. And the main point I want to make is that let's be in touch. Let's not, the relationship between the Home Office and the Spanish Chamber of Commerce should not end in this webinar. So let's continue the dialogue. Judging by the number of questions that were raised today, I'm sure that would be the case. So thank you very much, Blanca, Richard. Muchas gracias.
Gracias a vosotros. Thank you. Goodbye.